You might have heard of the prevention duty. I thought I'd do a quick video about what it actually means in the real world. It is part and parcel of the Homelessness Reduction Act, the HRA, which came into force back in 2018. And if you've been watching the news in England, you will know that homelessness levels are at record highs. So if nothing else, it's clear that the HRA has not been effective in terms of reducing homelessness. There's a number of different reasons for that. A lot of it's actually just down to this being very ill-conceived, but that's a whole other issue. In terms of what it means for individual people, is just because it's not seen that overall reduction in homelessness does not mean it can't be helpful in individual situations. So again, that's why I'm going to do this video, to try and explain how this might work and how it might help someone out, and I guess a couple of little pitfalls along the way as well, along with some kind of weird loopholes which I'm not actually sure was intended, but anyway, I'll come back to that. So you can make a homeless application to any local authority. Technically, pragmatically speaking, most of the time it makes sense to apply to your local authority where you've got a local connection, but you don't have to. And that's particularly the case with the prevention duty, because the local connection criteria does not apply anyway. And if you ask them for help with housing in some way, you don't have to use any particular terminology, and you give them reason to believe that you might be threatened with homelessness, then Section 184, the homeless application duty, has been triggered already. It's not when the council see you 3 weeks later or something and kind of, you know, take your details down. The moment you've actually made that application, as in you've let them know that you want help with housing and that you might be threatened with homelessness, that's when the duty starts. And if you're interested in that, watch the video on this channel called The Best Way to Make a Homeless Application, just to see how that works in practice. But if you do those things, basically the council has a number of things it then has to do. One of the first things of which is to establish whether in fact you are threatened with homelessness, and secondly whether in fact you are eligible for assistance, which basically means having recourse to public funds. If the answer is yes to both of those things, so eligible for assistance and threatened with homelessness, then that's when the prevention duty kicks in. And just a little bit, I appreciate I'm using a lot of jargon. Threatened with homelessness, again, is a technical term. It means it is likely that you will become homeless within the next 56 days, but you're not homeless now. If you're already homeless and you make an application to a council, the prevention duty does not kick in at all. It goes straight to the relief duty. That's kind of, I guess, one of the ways it divides up. I might return to that a little bit later to explain a few other things around that, but basically that's what happens. So the prevention duty is only going to be owed to people who are threatened with homelessness. And that leads us to kind of maybe the first interesting point of the video, is that if you are already legally homeless, the prevention duty should not be waved in your face at any point. And that might seem obvious, but in a lot of cases it won't be, because if you watch various videos on this channel, I've talked about the legal definition of homelessness a lot, and the legal definition of homelessness is not just not having a roof over your head, although that is part and parcel of it. Maybe the biggest category of people who are going to be legally homeless are people who have accommodation, but it's not reasonable to continue to occupy that accommodation. So for example, you are at risk of domestic abuse in your own home. You should never be dealt with under the prevention duty process, because legally speaking, you are already homeless. That's really important to emphasise. Lots of housing officers never get any good training on this anyway. Some housing officers know what they're doing and still deliberately do it wrong anyway. But basically, if you are at risk of domestic abuse now, then the prevention duty should not kick in. They should treat you as someone who is already legally homeless. And without going on too much of a tangent, in that situation, you're also potentially going to be in priority need, and therefore they would have a duty to offer you safe accommodation somewhere. As I say, I don't want to go too much of a tangent there. I've done other videos about that. So as I say, domestic abuse is not going to equal the prevention duty unless, and this is quite an obscure example, let's say you have been abused by someone, they're in prison, and now they're about to be released from prison, and it is likely that once they are released from prison, they're going to continue abusing you. So let's say the release date is within 56 days. Technically speaking, the prevention duty would be applicable in that situation, but obviously that's quite, as I say, quite obscure. Most cases involving domestic abuse should not involve the prevention duty. If you are at risk of abuse now, the prevention duty does not kick in, or should not kick in. You can complain about it if it does. That's one example. Another example on the same line is, let's say you are in unaffordable accommodation, as in you genuinely cannot afford your essential living costs, your food, your gas, electric, all that sort of stuff, and your rent at the same time. You might be able to afford one or the other, but you can't afford both of them. Again, you are legally homeless now. The prevention duty does not kick in, but again, councils regularly look at your details and say, okay, well, you know, at this rate, you're going to be evicted in a few months for rent arrears, so you're threatened with homelessness, but that's, again, just not how it works. So, and again, you might have situations where you are homeless because of disrepair issues, damp and mould, where it's really, really bad, affecting your health. You are homeless now. Prevention duty does not kick in. And also where you've got severe overcrowding. Now, overcrowding needs its own video really on this channel, which I haven't actually done yet, because it's quite complicated. Just because you're legally overcrowded does not mean you're homeless immediately, but essentially there is a point where you would become homeless. So again, if that is the case, then you should be dealt with under the relief duty, not the prevention duty. And again, just to give an example, kind of just to labour the point, let's say you are almost homeless because of overcrowding, and someone in the household is pregnant and they're about to give birth within the next 56 days, you would be threatened with homelessness at that point, so you would be dealt with under the prevention duty. So hopefully that makes sense. And it's also probably worth mentioning, in fact it is worth mentioning, that you will also be owed the prevention duty if you've been served with a valid Section 21 notice and it is going to expire within the next 56 days. Given that I'm recording this in 2025 and given that the law around Section 21 is likely to change at some point, I'm not going to say too much more about that. And I guess the whole point of the prevention duty is primarily, or firstly, that councils try to take action. I mean, the kind of technical word is they have a duty to take reasonable steps to help you to secure accommodation or maintain accommodation. That's kind of paraphrasing it a bit. So in most cases, what the council will primarily try and do is try to negotiate with your landlord to see if the landlord will keep you on. And this is where councils, or some councils anyway, act profoundly stupidly, because they'll say, okay, well, do you know what, it saves us a bit of money if we give some money to the landlord here so that they don't evict this person, so we'd have to pay for temporary accommodation and so on. And they think, yeah, that's a win. And in an isolated situation, that is true, that would be the case. It is worth paying money to a landlord to keep that person. The problem is, of course, is that landlords talk to each other, and once landlords realise that if they serve a valid Section 21 notice, they're going to get a lump sum of potentially thousands of pounds, guess what's going to happen a lot of the time? Landlords will simply evict people or threaten to evict people, get the payment, and kind of, laugh all the way to the bank. So that kind of action is incredibly short-sighted, but again, councils kind of do it. We've seen private companies kind of do consultancy for councils where they recommend payments. I mean, the one in Bedford was £3,500, which quite rightly was shot down by one of the councillors in the housing committee, who basically said it's obviously going to create a perverse incentive for landlords to issue Section 21 notices with no real intention of actually evicting them. So that's when the prevention duty applies. And there's this simultaneous duty. Again, it gets overly convoluted. I'm going to try and make this as simple as possible. I might be a little bit clumsy therefore, but again, I think in the real world this is probably going to be the information you need to know. At the point when the council accepts that you are in fact threatened with homelessness and you are in fact eligible for assistance, that's when the prevention duty starts. But there's this simultaneous duty which complements the prevention duty, which is the duty to carry out an assessment and also create a personalised housing plan. In most cases, the assessment and housing plan will be done before the prevention duty really kind of takes effect, but there would be situations where basically the council could act immediately to prevent you becoming homeless and not even do a PHP, and that would be fair enough in the right circumstances. But the assessment has to take into, why are you threatened with homelessness? And it might be obvious, I've been served with a Section 21 notice, no fault eviction. What type of accommodation I therefore need, and do I need any support to maintain it? Those three questions will be the basis of the assessment. I'm sure there will be other questions that the council will ask you, and on the basis of that assessment, the personalised housing plan will be created. Now, don't get excited. It seems when the people who wrote the legislation, when they wrote it, they thought, well, this is a great way to get housing officers to be genuinely collaborative and really kind of think outside the box to kind of come up with solutions. The reality is that most of the time you'll be just dealing with a template letter, which might even have someone else's details in from the last time they filled it in, which will be a data breach, but that's not another issue. And in it, the council's setting out these reasonable steps that they're going to take, and also reasonable steps that they are asking you to take. And that might involve things like going and looking for private rented accommodation. Often that'll be fruitless because the council will know full well that there's no affordable private rented accommodation available locally, but the council will probably offer things like financial payments to landlords as part of that to try and find alternative accommodation. Those kind of things that would kind of be relevant at that point. In my opinion, it's basically just a paper exercise. It's a waste of time. There's no real teeth to it. There is a little stick that the council can wave at you and say that you're unreasonably and deliberately refusing to cooperate with the reasonable steps, but actually that's a lot of work, and it's probably easier just to kind of not help and just let the prevention duty run its course anyway. I know some housing officers who will try and engage in that, but there's often a lot of defences you can raise. Let's say for example if someone's got caring responsibilities and they missed a sign-up meeting or something, that would not be an unreasonable refusal to cooperate at that point. They're just genuinely looking after their family member, or it might be they've got mental health issues and that's kind of stopping them getting to meetings or kind of dealing with the process or whatever. So although technically there is that kind of penalty of being deemed to have unreasonably and deliberately refused to cooperate, not only will that rarely actually be used in practice, but secondly, there's no real consequences on any subsequent duty if you were to do that. So The council can end the prevention duty if you don't cooperate, but then if you then become homeless, the relief duty will kick in, as it always would have, where there would be maybe a little bit more of a consequence if you didn't cooperate, but still it wouldn't be a fatal problem necessarily. But yeah, we're talking about prevention duty here, so I'll try and stay on track. So the reasonable steps that have been set out, as I say, will often be just kind of, templated tick box, paint by numbers type things. In some cases, the PHP will also get you to engage with mental health services or something, which personally I don't think is the council's place to advise that sort of thing. But again, I don't think anything's really going to come of it if you don't engage. But that's kind of some things that's going to happen at this point. So the assessment happens, the PHP is supposed to be collaboratively created, although often it'll just be this template that's thrown in your face. And then for the next 56 days or potentially longer, you're supposed to carry out your reasonable steps. As I say, the council will try and negotiate with the landlord a lot of the time. They will also, in theory, try and find accommodation for you that they can secure before you lose your current home, which means you don't have to become homeless. Now that is a win-win situation. I'm not quite sure how plausible it is to do it very often in this country at the moment, with the housing crisis being what it is, but it can be used in that sense, and again, that's kind of the purpose of this prevention duty. What's interesting about the prevention duty is that local connection does not apply. As I say, you can make an application anywhere, but pragmatically speaking, it makes sense to approach your own authority if it's safe to do so. Similarly, technically you can approach any local authority and kind of get the prevention duty when you're threatened with homelessness, but I'm not quite sure why you would do that in most situations. There will be some, I'm sure, and that's why the law's been set up like that. But what the council can do, although they can't refer you back to your home area in the prevention stage, they can liaise with that council to see if there are things that they can work together on and cooperate with between councils to try and secure accommodation for you during that period. But if the efforts weren't effective and you were then to become homeless, the council would be at liberty to refer you back to that home area at the relief duty stage. So as I say, or just technically just before the relief duty stage, I think. So again, I'm not quite sure how relevant that will be, but bottom line is people's situations are always different, and so it's just worth bearing in mind that you can approach any council in the country and you definitely can get the prevention duty with them. So without trying to sound too negative, the prevention duty will often be unsuccessful just by nature of the fact we have a housing crisis and so on. But so there are a number of ways that the prevention duty can end. One is that you withdraw the application. So you make an application to a council. You can approach multiple councils at the same time, by the way. Didn't mention that. You can do that. But at some point during the subsequent process, you withdraw your application. It might be you find alternative accommodation, in which case you're no longer homeless. So again, the prevention duty would end. Or it may be that it's not successful and you do then become homeless, at which point the prevention duty effectively becomes the relief duty. And I haven't actually said it yet, the PHP during the prevention duty should be monitored regularly because things can develop, things can change or whatever. And then that same PHP should develop into the relief duty stage. Obviously it might need changing at that point because you're now homeless, things are different. But it should be the same kind of assessment and kind of constant monitoring sort of process that should take place to make sure it's actually up to date and kind of actually makes sense. As I mentioned already, the prevention duty would end if you are deemed to have unreasonably or deliberately refused to cooperate. And there's some other obscure situations where it could end, like for example you cease to be eligible for assistance, so maybe your leave to remain has ended or something. And there's this really weird one which just makes me think that they really didn't know what they're talking about, but where you become intentionally homeless from accommodation which they've secured for you. Now, I don't see how that would work in the real world, because if they secured accommodation for you, then the prevention duty would end anyway and you'd no longer be homeless. So if the next day you then abandon that property or something, then you just make a fresh application. So I don't really understand what their thoughts were behind that when they kind of came up with that. But they did, it's in there, so I might as well tell you this. Oh, by the way, this is all in the Homelessness Code guidance, so yeah, worth kind of checking out. It's the most complicated and convoluted bit of it probably, and this is the reason I don't like it. It's got the least teeth to actually get you housed, because if you are making a homes application to a council, the most important thing is whether you're going to be owed the main housing duty, as in you're homeless eligible in priority needs, not intentionally homeless, and you have a local connection or local connections taken care of. I would say focus on those things. Probably the most important thing for most people is going to be showing that you're in priority needs. And for families who are automatically in priority needs, it's probably going to be about showing that you're not intentionally homeless. But that's kind of an overview of the prevention duty. There's a few other weird things that happen within it, which I'm going to say at the end, but it's probably not going to be very relevant. And one is that when the council work out if they're going to try and secure suitable accommodation for you during that prevention stage, it's ridiculous, it's absurd logically. They need to apply a different standard to you if you're in priority need. So if you're in priority need, you should get a better quality of housing than if you were not in priority need. The only thing is at the prevention stage, there has been no decision yet about whether you're in priority need. Again, I don't really understand what the thinking was here, or whether they actually thought it through. It seems to me to be just kind of like an artifact of a previous version of the HRA kind of as it was created. I know they did change some things about the HRA which made a big difference, because basically their original plans were too expensive to actually afford. I guess the big picture thing is that the prevention duty is just like an automatic thing that happens if you approach a council when you're threatened with homelessness. It means the council have to take reasonable steps to try to help you to find alternative accommodation or remain in your own home. You have to cooperate with those steps, but in the real world often that won't be successful, and that may well mean that you subsequently become homeless, and therefore the relief duty will kick in. The prevention duty ends and the relief duty kicks in. Also, I'd say, just to finish, just be wary of your options in the prevention stage, because particularly for single homeless people, but not just single homeless people, the council might try and throw you into a supported accommodation project, which, for reasons I haven't got time to go into in this video, are basically a bad idea in almost all cases, because you drastically reduce the amount of options you have once you're in supported accommodation in terms of getting proper housing again. There's a much higher risk of being, kind of losing your accommodation, because there's much less security on it. And out of the hundreds of people I work with who've gone through this process, almost all of them would prefer to get their own house or their own home rather than have to share in a supported accommodation environment. And I doubt many housing officers actually explain the consequences of accepting supported accommodation. They probably make it sound amazing, like you're going to get this amazing kind of VIP treatment, and they're going to look after you, and staff's going to be great, and they're going to deliver all this support. That is not the reality in the vast majority of supported accommodation projects. So I would say in that prevention stage, it's still worth getting some independent advice or kind of advocacy from somewhere which just lays out your options, and that will vary from place to place. But certainly I've seen housing officers try to force people in and kind of make out like if the person didn't accept supported accommodation then there'll be no other help available. That is not true. I think when you're dealing with housing officers trying to say that, go back to basics, get it all in writing, and if they say anything about the consequences of you rejecting an offer or refusing an offer, and just get them to put it in an email to you so you can then digest it. And even then I'd be fairly dubious about housing officers actually being honest. As I say, it might sound like I'm overly sceptical, but I've seen a number of cases where people were told they had no other option but supported accommodation. They then accepted it. They then found out they hadn't actually needed to accept it, and then that kind of leads to a whole load of rubbish down the line. So yeah, anyway, hopefully that helps. I'm not entirely sure if I've covered everything I need to cover. If you've got any questions about it, do put it in the comments. I'll get back to you either directly in the comments, or I'll take you to the next weekly live stream, usually on Thursday evening. But other than that, I hope this was helpful, and hopefully it makes sense and isn't too ridiculously convoluted. Yeah, as I say, I'm not a fan of it all, but it is what it is.